Today we're going to talk about trusts and explain what they are and how we categorize them. My name is Gregory Singleton. I'm an estate planning and probate attorney who works for Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, we're going to be talking about Minnesota law, though a lot of the topics and theories that we talk about are going to translate to other states. Just make sure you talk to an estate planning professional in your state when you sit down to do your estate plan. And second, this video is for educational purposes only. I am not establishing an attorney-client relationship with everyone online. With that said, let's get going. I realized when I was sitting down to do some scripts that I've kind of taken it for granted that people know what a trust is. We've talked about trusts and some of the characteristics of trusts, but let's look at the universe of trusts and kind of break it down here. A trust, very simply, is person A gives property to person B to hold for person C's benefit. My simple definition is giving something to someone through a middleman. The terminology that we use is person A is going to be the settlor, that's the person who forms the trust, and the grantor, the person who funds the trust. Person B is going to be the trustee, and person C is going to be the beneficiary. Now, of course, we can get a little more complicated with this, but that's the basics of what you need to know. Now, there are two distinctions for trusts that, or characteristics really, of that how we categorize trusts. There's more, but these are the basic ones I want to talk about today. The first is whether the trust is revocable or irrevocable. And second is whether the trust is inter vivos or non-inter vivos. And to break it down even further, there's really only three types. There's revocable inter vivos, irrevocable inter vivos, and irrevocable non-inter vivos. And I'll explain why in just a moment. But let's start with the revocable. Under Black's Law Dictionary, which is the legal dictionary that most people use, a revocable trust means that the settlor reserves the right to terminate the trust and recover the trust assets and property and any undistributed income. So we mostly talk about revocable living trusts because that's what the revocable trusts are. During life, the person who creates the trust is the settlor. They're also usually the grantor who funds the trust. They're also the trustee who manages the trust, and they're also the beneficiary, all at the same time. I like to explain it like when someone's creating a trust, is like they're creating a box. While you're alive, you can put stuff in the box, you can take stuff out of the box, you can move the stuff around in the box, you can reform the box into be whatever you want it to be. But when your stuff is in the box, technically, the box owns your stuff. You own the box, so realistically, you kind of own the stuff, but the box owns your stuff, and therefore you're able to avoid probate. We talk about how to avoid probate in other videos, so I won't belabor that. Realistically, the box is just a legal fiction. It's not recognized by the IRS. You don't have to file a separate set of taxes because you have a revocable trust. When you die, the box acts just like a will. There's a new trustee who acts like your personal representative. There are new beneficiaries who act like your devisees and heirs, and the trust becomes non-revocable for the term of the trust administration. A couple characteristics that are important is that there is no creditor protection for the assets in a revocable trust while it is revocable. The settlor is the beneficiary, therefore you don't get those protections. It's called a self-settled trust. Secondly, a revocable trust is very similar to a will, other than the fact that you avoid probate. I define them both as vehicles for giving away assets at your death. That's what they do. That defines them both. But let's talk about the difference in going into irrevocable trusts. Because when you have a revocable trust, when you die, it becomes irrevocable. An irrevocable trust is a trust that cannot be terminated by the settlor once it is created. That's according, again, to Black's Law Dictionary. So if we're using the box analogy, you put the stuff in the box, you can't take stuff out of the box unless the box says you can, and you can't reform the box. The box is what it is when it's created. Now, there's a couple characteristics of this. For tax purposes, the trust has to have its own tax identification number. It has to pay its own taxes. Second, you do get creditor protection if the trust is set up properly, because it is not a self-settled trust. Third, there are two primary uses for an irrevocable trust. One is for asset protection, and the other is an estate planning tool. So let's look at those two, and that gives us the difference between inter vivos trust and a non-inter vivos trust. An inter vivos trust is a trust that exists while the settlor is alive and during their lifetime. A non-inter vivos trust is one that is created after their death. So an inter vivos trust is primarily for asset protection. Again, you put your stuff in the box, you can't take it out of the box. It's an irrevocable trust that you're basically giving your assets away to. Now, there's a few uses to this. The big one is just to give gifts. You can see the result of the gifts while you are alive, and maybe have someone else manage your assets and you don't have to look over them. There's a couple different types that we use. There's many different types we use. There's crummy trusts, which are giving gifts. There's disability asset protection trust. There's Medicaid protection trust. There's charitable trusts. There's a whole variety of different types of trusts that we create while we're alive, but are irrevocable. But they're all basically for asset protection. The non-inter vivos trust is again going to be an irrevocable trust that is created in the terminal document, and the terminal document being a will or revocable living trust. I want to remind you that we can't have a non-inter vivos trust, which is created after you die or upon your death, that is revocable, because a revocable trust means that the person who created it has to be able to terminate the trust. And since you have died, you can't terminate the trust. When we have a trust that is created in a will, it's called a testamentary trust. When you have a trust created in a revocable living trust, it is a sub-trust or a nested trust. I like nested trust. Realistically, A, they're the same thing, and B, most people just call them all testamentary trusts. It has several uses for creating an irrevocable testamentary trust. First, primary one is gift giving. You can control assets beyond the grave. You can distribute assets over time, like give someone an income on a monthly or annual basis. You can distribute it after an event or date, such as after someone turns 28 years old or after someone gets married. You can control the use. You can make sure that the assets are only used for education or a down payment on a house or to start a business or to raise children under the HEMS standard, which is health, education, maintenance, support. You can control the use for charities and how it is used for charitable institutions. The other thing you can do is create conditions to it, such as the spendthrift trust. Say you put money into a trust and you're going to give it out to someone over time, but you put in a provision that says if they get into drugs, they do not get any more payments until they complete rehab. That's a spendthrift trust, or a spendthrift provision in a testamentary or a nested trust. There's a couple characteristics which are important. First of all, there's no separate document. The trust is created in the revocable living trust or in the will. As such, the revocable living trust itself or the will itself is the document that establishes the trust. If you create an inter vivos trust that is irrevocable, you are going to have a separate document for it, but not if it's testamentary or non-inter vivos. Second, it has to be irrevocable. The settlor, the person who created the trust, is dead. They cannot terminate the trust, therefore it must be irrevocable. Third is you can get creditor protection. If the beneficiary and trustee only has limited ability to establish the terms or change the terms of the trust, you can get creditor protection. If it's drafted wrong, however, and give too much power to the beneficiary and the trustee to change the terms of the trust, you get no protection at all. So that's my take on an overview of what the three different types of trusts are, and those being revocable living trust, irrevocable inter vivos or living trust, and irrevocable testamentary or nested or sub-trust. If you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. We do a new video every other Wednesday, and we got some great ones coming up, so keep an eye out for those. If you have any questions, leave them in the comments below, or just send me an email. My email will pop up at the end of the video. Otherwise, until next time, this is Gregory Singleton with Signature Law.